And finally, please ensure you're sticking to social distancing protocols during this meeting, if that's relevant to you in your situation right now. So this meeting was intended to be live streamed. Unfortunately, we're having some technical issues with that, but the recording will be on the DPA webcast site should you wish to view it. Graham confirmed that will either be later today or all being well by tomorrow lunchtime. So by participating today, you're consenting to the recording, storage and use of this material for webcasting, for training and for the keeping of records that are accessible by the public. I'll be keeping a note of our discussions too this morning, which I'll circulate within the next 7 days. And this will set out all the procedural arrangements we discuss this morning and hopefully also finalise. Can I just check, do you all have sight of the agenda and its appendices, including Appendix 6, which was circulated on Monday last week? Mr. Campbell, please. I see you've got your hand up. I think you're still on mute, Mr. Campbell.
I was just signifying that I had it, sir. Good morning.
Ah, lovely. Good morning. Thank you. That's great. Okay, if anybody doesn't have it to hand, you can get it on the DPA website on page reference, which is WIN-170-2006. So whilst we're doing introductions, you'll have a chance to get it if you don't have sight. Are there any questions at all at this stage? Any kind of housekeeping points that anybody wants to clarify? No. Okay. Lovely. So we'll move on to item 2 on the agenda, which is introductions. So I can record who's in this meeting today. So as far as I can see, I think now we've got everybody who had opted in and who I was expecting to be here or represented today, but I'll just need to double check that. Can I ask parties who are actively participating to introduce themselves and any other key members of their team who are on the call today? So who's here for the applicant, please.
Then good morning, sir. My name is David Hardy. I'm duly qualified as a barrister and solicitor with Squire Patton Boggs, and will be appearing as counsel at the inquiry. In terms of key members of the team, then Robin Hutchinson, who's a partner with CMS, and then Kirsty Kelshaw, who is legal counsel with the client. They're both likely to be speaking. Other members of the team who are available but not intending to speak at the moment, Brian Denny and Dale Turner from Pegasus in relation to landscape and visual matters. And then, as I think we already know, David Bell from David Bell Planning, who will be dealing with planning and policy matters.
Good morning, sir.
Good morning. Thank you, Mr. Hardy. That's helpful. And who's here for Dumfries and Galloway Council, please?
Good morning, sir. My name is Peter Ferguson. I'm a partner at Harper MacLeod Solicitors and I represent the council. And with me today are Andrew Robinson, who's a senior planner, and Robert Duncan, who is a team leader in the major developments team.
Thank you, Mr. Ferguson. And for East Ayrshire Council, please, is it Mr. Wilson?
Good morning. Yes, it is David Wilson. I'm an acting team leader from East Ayrshire Council's Development Management section.
Thank you. And for Glasgow Prestwick Airport, please. I think we've got a couple on the line. Who's taking the lead, please?
Good morning, sir. My name's Douglas Blythe. I'm a partner in Denton's. I'm acting for Glasgow Prestwick Airport. I'm joined today by Senior Associate Amy Cornelius and Steve Thompson from Glasgow Prestwick Airport.
Thank you. I was struggling to spot you on my screen then. I was trying to work out who was speaking, but I found you now. Thank you, Mr. And for RSPB Scotland, please. Is it Mr. Tooth?
Good morning. Yes, I'm Ed Tooth, Conservation Officer for RSPB Scotland. Also on the call is my colleague Louise Gunstanson, who is our Senior Conservation Planner.
Lovely, thank you. Now, Mr. Campbell, are you representing the Stop Sanquhar 2 objection group or individuals? Could you clarify who you're
Thank you. Good morning. Good morning, sir. I'm John Campbell. I'm the Queen's Counsel at the Scottish Bar, and I'm representing Stop Sanquhar 2, constitution of which is somewhat fluid at the moment, but as it presently stands, 15 households and 6 perhaps 7 community councils. With me today are Sue King-Smith and Sue Hall, who are on screen, Karen Coltart, who's also on screen, and I don't see anybody else that I recognise.
Thank you, Mr. Campbell.
So,
Okay, and then I will work through my screen to see who else we have on the line. I'm expecting Mr. Mundell. Mr. Mundell, yes, you're with us. Good morning.
Good morning. I'm Oliver Mundell, and we're currently in the election period, so I'm not permitted to describe myself as an MSP, but because of the current COVID regulations, I continue to sit in the Parliament on behalf of Dumfriesshire constituents, and given that the inquiry will take place after the election, if re-elected, then I do plan to participate.
Thank you. That's right. And as I said before, we're not talking about merits today anyway, so hopefully that won't put you in any kind of difficult position this morning. Thank you. So then I've got Mr. Menny, please, on the John Menny.
Yeah, it's John and Lorna Meany. It's and we have residents in East Ayrshire down at New Cumnock.
And
Good morning.
Craig's Farm Stading.
Yes, thank you. And Mr. Oxley, please.
Yeah, good morning. Graham Oxley. I'm the commercial MD with Energy, an energy supply company based in the UK.
Thank you. And Ms. Coltart, do you intend to speak this morning, or are you represented by Mr. Campbell?
Morning, it's Mr. Campbell who's going to be representing me. Thank you.
Okay, good morning. Thank you. And Ms. Hall, good morning. You're still on mute, Ms. Hall, I think. I can't hear you. I think you can give me a nod if you're. I understand you're represented by Mr. Campbell as well. I just want to make sure that you're. Yes, happy, good. And Ms. King-Smith, does the same apply? Mr. Campbell speaking for you?
Yes, that's right. Mr. Campbell speaking for me.
Lovely, thank you. Have I missed anybody who off that list now? Have I heard from everybody who I was expecting to, or who was expecting to introduce themselves? Can't see anybody else on my screen, so unless anybody's dropping off.
Mr. Campbell speaking for me as well. Sharon Mooney.
Ah, Ms. Mooney, thank you, yes.
Thank you.
Lovely, okay. Right, we shall move on to item 3 on the agenda. I'll actually take items 3 and 4 together because they actually link together somewhat currently in terms of procedures and so on. So, so unlike in extreme planning cases, there are no prescribed rules for the conduct of inquiries held under Schedule 8 of the Electricity Act. So the DPA has therefore published a code of practice for handling inquiries under the Act. Now, the code of practice in essence aims to ensure a fair, transparent and efficient process, and these broadly mirror current planning appeal regulations. Now, some of the parties present, I'm sure, will be aware of the code. It's available on the DPA website, and I'll also put a hyperlink to this document in the notes of my meeting, as I intend to follow the code as far as is practical in this case. But in essence, it gives flexibility, so we can apply flexibility so we have the right procedures for the right topics. Now, in terms of COVID restrictions, and I'll take any questions on that in just a moment. But in terms of COVID restrictions, currently the DPA's position is that in-person inquiry or hearing sessions cannot be held. So we need to plan to hold sessions virtually. Of course, this situation is ever changing, hopefully improving, and depending on the dates that are settled on, which we'll come back to later, it may be possible to have an in-person inquiry. I really hope that will be the case, but we can't expect that. So even if an in-person inquiry becomes possible, we would likely need a COVID-safe venue with with a substantial amount of space so that social distancing can still be observed. So this means things like having one-way systems, 2-metre gaps between parties and so on. So with all that in mind, it may not be possible to hold the inquiry locally for that reason. So a venue in Dumfries, for example, may be more likely. So for now, if you could simply advise the case officer, Jane Anderson, and I'll give you her contact details in the note of the meeting. If you advise Jane of any possible larger venues that sound like they might fit that criteria, that would be really helpful. But as I say, we should expect currently for all sessions to be held online. Does anybody have any comments or questions about that? Yes,
So
Mr. Hardy.
yes, if I may, I mean, but plainly, I think all parties that would have a preference for an in-person inquiry if we can. And just echoing what you said, what we have done is identified some venues. So if it was possible, if things open up to have an in-person venue, to look at those, and they do include some of the hotels in Dumfries. So we've got a list of about 6. There's one that is mostly available. So just to say, the background work has been done there. There are places available, and one option might be to have a second PEM at some point in the late summer, and we were thinking perhaps late August, almost to have a rain check on the COVID situation to make a final decision about in-person or virtual, if you thought that was helpful.
Yeah, well, I'm certainly very, very open to the possibility of this type. I think we can play it by ear. I don't think we need to set that necessarily today and confirm it, but I think as we progress, if things are looking uncertain and we don't know how we might potentially be progressing, then I'll certainly set a second meeting just to confirm everything. Thank you for finding the hotel options. That's going to be of great assistance should we need them. Does anybody else have any questions or comments? Ms. Hall, were you putting your hand up then? I saw no. Okay, no problem. Okay, lovely. So we'll move on. So I'm now on item 5 on the agenda. So it would be helpful if you could have Appendix A to hand for this item, where I've set out my view on what may be the most appropriate procedures for each topic, and this is very much up for discussion. And as I say, the code gives flexibility on this in terms of how we deal with each topic. In any case, I should say at this stage that this should not be interpreted as a judgment on the relative importance of one topic over another. It simply means that for some matters, I'm currently satisfied that I've enough information on that subject to be able to advise ministers. It's also standard practice to have a session focused on conditions, but this doesn't mean I've reached a view on the merits of the case. So the code of practice explains what's involved in each type of procedure and the submissions which would be needed to be made by parties in advance, and I'll come back to this shortly anyway. But very briefly, in an inquiry session, each witness gives evidence in chief by reading out all or some of their recognition, and that's a document that sets out their submission to the inquiry. Now, if the witness is being represented, then the representative may ask initial questions or seek to clarify points in their evidence, and after that they'll be subject to questioning by those of a opposing view. I may also have questions for the witness. It's not necessary to be represented, and individuals are welcome to give their own evidence and to question other witnesses. Now, in a hearing session, there's no formal representation. Hearing sessions take the form of a structured discussion, which would be led by me. So they're more informal in nature, but they're less well suited than an inquiry where there are complex technical issues in dispute. Obviously, further written submissions are a third option, and that's very much what it says on the tin. I would set out certain questions that I would ask parties to respond to, not necessarily all parties, and then other parties would have a chance to comment on those responses. So with all that in mind, you'll see that I've outlined that I'm proposing 2 inquiry sessions. One on landscape and visual effects. Now this would cover cumulative effects. It would cover landscape and visual effects of aviation warning lighting, so making that distinction from the second session, which I'll come on to, and residential visual amenity as well. I'm proposing another session, another inquiry session for the implications for aviation radar and systems. In terms of hearing sessions, I'm proposing one session on energy and planning policy and a further session on conditions and legal agreement. Now, the scope of conditions would obviously be potentially wide-ranging, but I'm anticipating that there'll be some work done in advance to produce a schedule of conditions, and it'll be clear as to where the councils have agreed with the applicant appropriate wording and scope. One of the matters to be discussed here, I think, would be noise limits and mitigation or monitoring, rather than potentially hold a separate noise session, but we can discuss that. Now, I tend to ask for further written submissions on the potential effects on birds. Now, this is in regard to principally matters raised in the RSPB objection, but also the potential implications of aviation warning lighting upon birds. I've not ruled out an inquiry session to consider the effects on birds at this stage, and this will, I think, depend on what these further submissions set out. My suggestion is that there would not be any further procedure on any other topics, but as I say, this is very much up for discussion now. So on that note, I'd like to hear parties' views on what I've outlined. I'll start with the applicant, if that's okay. I'm also mindful of the applicant's email of Friday last week, which outlined its intention to submit additional information. So perhaps, Mr. Hardy, you could also say a bit more about this, please.
Yes, thank you. Well, let's do with the topics and subjects first. So in short, we agree with what's been said in relation to L&B, aviation, energy and conditions. In relation to ornithology, then split into the two parts as you've indicated. I think we're hopeful. Obviously, RSPB are on the call this morning that actually there may be agreement reached, and I think the position would be that if the RSPB were to withdraw without qualification, then the view would be that you've got enough information and no further procedure would be required. I think if there was a qualified withdrawal, then a statement of common ground or a statement of agreed matters would be sensible in relation to that. If neither of those work, and in fact the objection still remains, then written submissions on the general points, and we agree that there ought to be, if that's what you're seeking, then there ought to be written submissions in relation to the impacts of aviation lighting. So on the general matters are in relation to ornithology, hopeful that they may actually go away and nothing further is required. But if they don't, written submissions or a statement of agreed matters, and then written submissions in relation to aviation, the impacts of aviation lighting on birds, and then agreement on no further procedure on any other topic. So that's that. In relation to additional information, the email was circulated on Friday. That should have gone round to all parties. There was a note attached as to what that was going to include. So the request would be that you request further additional environmental information for the purposes of the regulations. So I don't know whether you need me to go through what's on that proposed content list. I think if people have got it, it's self-explanatory. I do have some comments about dates for when that is likely to come in. And I do think that there needs to be a date, which I'll term the guillotine date, for consideration of other schemes. Otherwise, it just goes on. And I was going to propose a date for the end of, say, May as being the drop dead date for assessment of other schemes in the system. That I hope is sufficient, unless there's anything that you want me to elaborate on.
Not right now, thank you, Mr. Hardy. That's helpful. Can I just check? Have all the parties on the call seen the email and attachment? I understand it was circulated. I know we circulated it to individuals because obviously Mr. Hardy and his team don't have private email addresses. I'm not seeing anybody shaking their heads. So, okay. So can I come to the to Dumfries and Galloway Council now, please, for its views on what I've set out and what Mr. Hardy has just said.
Yes, thank you, sir. The council agrees that that an inquiry session on landscape and visual effects would be appropriate, and of course the council will participate in that. The council would not be involved in the second aviation inquiry session. And again, it seems appropriate for there to be a hearing session on energy planning policy and conditions and legal agreement. Turning to further written submissions, the council wouldn't intend to be involved in further written submissions regarding ornithology issues.
Okay, thank you. Mr. Wilson, please, for East Ayrshire Council.
Thanks, sir. The council would only intend to participate in the hearing session on the conditions and legal agreement. Council, as you're aware, had no objections, so we don't intend to participate in any other sessions.
Okay, that's fine. And Mr. Blythe, please, Glasgow Prestwick Airport.
Yes, thank you, sir. In relation to the first inquiry session, landscape and visual effects, to include aviation warning lighting, as matters stand, I'm not anticipating Glasgow Prestwick having any involvement in that. That's subject to one caveat, and that one caveat is having sight of the revised proposals in relation to aviation lighting. You'll appreciate that aviation lighting has an aviation safety implication, and it does seem to be suggested by the applicant that the aviation lighting proposal will be such that will be discussed with the CAA and approved by the CAA. So I'm not anticipating any problems. The airport has an interest in ensuring that the lighting which is proposed is effective in that respect in terms of ensuring aviation safety. So I think until such time as I've seen the revised proposal in relation to aviation lighting, I can't give a concluded view on that, but suffice to say, I think it's probably unlikely that GPA will participate in that first session. As far as the inquiry session to do with effects upon aviation radar and systems is involved, I would anticipate Glasgow Prestwick Airport being involved in that session. However, it would be of assistance, I think, if we could receive a better explanation from the applicant as to the issue which is taken with regard to engaging with Glasgow Prestwick in relation to mitigation. If I can give a little bit of a flesh to the bones in that respect, the wind farm will create clutter on radar systems. You know, that the consequence of wind farms, that's well understood, and that clutter causes an aviation safety issue, because in effect the radar cannot see behind or above the wind farm. Now, there's two radar systems which will be impacted by this wind farm. One is operated by Glasgow Prestwick Airport, and the other is operated by NATS. Now, as I understand it, an agreement, and both of the clutter problems are pretty similar for both NATS and GPA, and both of them ought to be capable of being mitigated through the use of second primary radar systems. Now, as I understand it, an agreement has been reached between the applicant and NATS in relation to a mitigation solution involving a second radar by NATS. And a similar mitigation solution has been proposed by Glasgow Prestwick Airport, but there's been no engagement whatsoever in relation to trying to reach an agreement in that respect, despite various attempts by the airport. And as I understand it from the EIA, it seems to be suggested that the second radar which GPA has will simply solve the issues, but but that isn't necessarily the case. So there's a degree of testing, etc., which is required. So I think in short, it would be helpful to understand what the applicant's position is in relation to the mitigation solution which is being proposed by Glasgow Prestwick Airport, and whether or not there's going to be any engagement in that respect. Because what I want to avoid is going to the very considerable expense of an inquiry session, only for that to be completely unnecessary, if ultimately a mitigation solution is going to be entered into, as it's been entered into with NATS. So I don't know how that can be worked, sir, in terms of the timetable, but there has been a suggestion from the applicant that further reports are going to be made available. My understanding is that these are going to be available this week, which are hopefully going to flesh out in further detail the applicant's position. But fundamentally, we need to understand why it is that the applicant has entered into an agreement with NATS, but seems to be reluctant to have any discussions with GPA.
Okay, thank you, Mr. Blythe. I've got to be careful here that we don't stray into merit, so it's helpful to have the context from your perspective. I don't want to get into the merits of it. Obviously, given the dates that I've indicated may be suitable for the inquiry session, there's a fairly substantial window of time there to be able to continue discussions with the applicant, and if they can be resolved ahead of an inquiry session and also ahead of associated deadlines for in terms of the lead-in, then if that's resolved and I'm satisfied that it has been resolved, I wouldn't still pursue an inquiry session. So obviously we wouldn't have any kind of unnecessary inquiry sessions. We would only be focused on matters where there are disputes still present. Now, clearly, it sounds like there is a tension there and issues there that haven't been resolved, and that would, as it stands right now, if progress isn't made, that would be part of the focus of the inquiry session. I don't know if Mr. Hardy, you would like to say anything in response.
Yes, just very briefly. I mean, in short, there's no difficulty with engaging at all, and that will take place. The technical reports that were mentioned actually came in from the consultant. So that's a Mr. Adam Parkinson from Aegis. They came into the clients late last night, so they will be sent on to Glasgow Prestwick very shortly. I suspect that there will still be outstanding issues that will need to be negotiated, and there's a requirement from our side for an inquiry session by way of backstop. Clearly, if that issue can be negotiated away, then, as you say, we won't need the inquiry session, but it does need to be there on a protected basis at the moment.
Thank you. That sounds sensible. I'm keen to keep the inquiry session in place right now, because it's not a matter that I could adequately report on currently without having further evidence and clarity on the dispute.
Yeah, absolutely agree.
Understood, sir. And that indication from Mr. Hardy is helpful. I'm just conscious of the fact that getting into aviation radar and systems will be a pretty involved process, which therefore will be a lengthy process. Quite sure you would prefer to avoid it, sir. And it does seem to me that this all ought to be capable of agreement. We just need engagement to get to that point of agreement.
Well, time will tell on that, and we'll plan for the inquiry, I think, on that basis. And obviously, if we don't need it, we can cancel that session. That's no problem at all. Okay, Mr. Tooth, please, on RSPB.
Thank you. So, yeah, we received further information from the applicant on the 8th of April with regards to the issues we raised in our objection for both ornithological receptors and deep peat habitat. So at present, we're processing that information with input from colleagues. But certainly at this stage, we agree with the preliminary view on further procedure. So if we participate in the inquiry, we envisage that written submissions will suffice. And if a qualified withdrawal is possible, then a statement of agreed matters could be drawn up.
Okay, can I just? I didn't quite catch what you said in terms of what your view was on the session. So you wouldn't think an inquiry session would be necessary?
We'd be happy with written submissions.
Further written submissions.
But we're still formulating our final position.
Okay, that's helpful to know. I'll reserve judgment, because it's kind of crystal ball gazing right now in terms of where we end up, because I haven't seen the information and I haven't seen your response either. So it's somewhat difficult to form a final view. So we'll keep that open ended.
Brilliant. Thank you.
Thank you. Mr. Campbell, please.
So good morning again. Having looked at your agenda, sir, we are in agreement with what you have written in relation to inquiry sessions and proposed hearing sessions.
Okay.
There is remaining concern amongst those I represent on the matters of private water supplies and the effects on them. And we have yet to study and understand properly the submissions made on noise in the Environmental Impact Assessment Report. I don't know whether further additional information on noise is to come forward, but I expect we can conclude our scrutiny of that in a reasonably short time. There is also concern amongst those I represent on what I might call generally matters ecological, that's to say both ornithology and peat questions. We are at the present time studying what we have. I would expect, though, that if there is a remaining question, it can be taken up with the applicant, or at worst, be the subject of a written submission to your inquiry. So, sir, in short, we would support an inquiry session on landscape and visual effects, which is the principal matter. We would wish to be an observer on the matter of aviation lighting if there is an inquiry or hearing, because that is clearly a matter which has an impact. But of course, I don't offer to field any expertise on that question. So far as energy and planning policy and conditions are concerned, in relation to the first, there will be observations to be made, sir, at a hearing. In relation to the second, with some diffidence, I would like to see the draft conditions as they emerge. Obviously, the enforcement of draft conditions is not a matter for individuals, but for local authorities, and therefore the extent to which one can influence the content is limited. However, with experienced people, it can often be the case that conditions can be improved and made to work properly. So I would like to ask Dumfries and Galloway if they would be good enough to circulate the draft when it starts to evolve. I don't think I have anything else, sir, just at the present.
Thank you, Mr. Campbell. And just to clarify, so in terms of the concerns around private water supplies and noise, what's your view in terms of how I should proceed on those matters? Do you, in terms of noise, I indicated before that my view is that potentially the conditions session might be the appropriate forum to focus on that. Do you agree with that?
No, sir, with respect, I don't. Experience suggests that if noise is genuinely an issue, then a condition session is not a good place to ventilate those concerns, because, as you know very well, it's a technical matter, takes a long time to explain, and condition sessions tend to be very protracted anyway. What I would suggest, though, with respect, is that you allow me perhaps 3 weeks, perhaps 4 weeks, to let you know definitively whether or not I would wish to field evidence in either of those areas. And if I do, then you can make a decision about what form of examination should be applied to these topics. I would not think from experience that an inquiry session on either of those topics would be necessary. Perhaps a hearing, perhaps in writing, but I would say, again from experience, I would say not an inquiry session. So I hope that's clear.
Yes, thank you. That's very helpful. And I mean, in terms of giving you the opportunity to look into that further and to give me some feedback, I'm very content with that as a way forwards. We've got the benefit of having some time and flexibility in the timetable that I've outlined. Now we'll come on to that later, but I'd suggested in terms of dates, kind of further written submissions would be requested by the 17th of May. I mean, if I was hearing back from you as to what your firm view on this was by that kind of date, I would be satisfied with that, Mr. Campbell.
Thank you, sir. There's another inquiry in South Ayrshire, which you may be aware of, called Cloughery, which is coming up very shortly, and so there's a bit of a clash there. But I'm sure that 28 days more or less. I'm sure
approximately, yeah.
Yes, I'm sure that would be sufficient time. So yes.
Mr. Hardy, do you have any comments on what Mr. Campbell has outlined there?
Well, I think it's disappointing that there isn't a more prepared position for this meeting. The information has been available for a long time, but that is as it is. I mean, our view is that there's nothing further required on any of those topics. So you've got sufficient information in relation to private water supplies, to peat, to ecology and ornithology, subject to the points we've already discussed. Noise, there were no issues. That's been again available for a very long time. So that's our position. I can't really say much more. We think you've got enough, and nothing further is required. But if you're going to allow Mr. Campbell and his clients to come forward, then we'll just have to wait and see.
Yeah, I'm happy enough to have Mr. Campbell outline his position further in more detail. I think that's helpful. The last thing that I want to do is get to the end of the inquiry session and think I wish I'd asked more questions about a certain topic. So I'd like to see it up front now. We've got the time in the timetable in this case, so I shall allow that, and then I can form a final view. And again, if I was to have a session on particularly a session or further written submissions, then that would be a matter for a second PM to actually pick up. Mr. Campbell, see you've got your hand up.
Just to say, while I take on board Mr. Hardy's comments, this group has recently come together, and so since its resources are limited, that is why further time is being sought at the present.
That's noted. Thank you. Okay. So, Mr. Mundell, do you have any comments on the procedures that have outlined?
I've got a couple of comments. The first one was around the mention of a guillotine date. And I wasn't clear entirely what that meant, because I'm certainly aware of a neighbouring scheme that's gone to judicial review, and I would just be keen that you're in a position to look at all of the relevant facts, as the inquiry starts, and I didn't know when we were talking about submitted schemes, having a cut-off date. Just what that meant, and then a second thing was just around East Ayrshire Council, and whether they would be available as part of the inquiry session, given that they have made comments. I know that they're now in agreement, but they previously have raised concerns, and it might be of interest to understand what's changed from their point of view, in contrast with the decisions Dumfries and Galloway Council have taken. And then the third thing was on noise. I would be keen, I'm not asking for an additional session on it or for any detail, but I just would be keen that if any individual participants want to comment on noise as part of taking part in the inquiry, that wouldn't be that wouldn't be kind of ruled out, if it was in passing, or they wanted to raise it as a general concern. But that was really the 3 points for me.
Thank you.
If I may say, just in terms of guillotine phrase, just so that there is certainty as to what schemes are taken into account in any cumulative impacts. Clearly, things continue to evolve. You need to strike a balance between having things as up to date as possible for the inquiry, but also a line drawn at a point where meaningful information could be supplied and people get the time to look at it. So that's what I was indicating, and I suggested the end of May as being the right sort of point. But I'm a few weeks either way. I'm not going to say anything about, but I do think we need some certainty.
I would just think if there are major schemes that come forward, before the inquiry starts in October, they should be, it should be possible for them to be considered. I think that certainly from inquiries I've taken part in the past, there have been, there have been new schemes that do have a knock-on impact, and I think it's only right if that information is in the public domain that it forms part of the consideration. And I think for ministers making the final decision, it is relevant to know if there have been further schemes submitted. So
I would prolong what perhaps has become a conversation. I think you hopefully will have got the point. There needs to be certainty for the assessors. These things are not, they're not straightforward, they take time to do. There needs to be certainty about what schemes are going to go into the baseline and can be taken into account. So it can't just be left as, oh, well, let's see what comes in before September or October. So the principle of a guillotine date, I think, is a good one. I'm suggesting the end of May, and I don't know, maybe you, if that finds favour, but I'd certainly would encourage you to draw a line somewhere.
I'll step in now. I think it was risking becoming a conversation there. So I'm satisfied that there is a cut-off point, because obviously visualizations of wirelines and so on, and evidence has to be prepared at a certain point in time. We have to take into account the fact that if something changes, if new schemes come in, I would have to consider how I take account of that. And if it was, for example, sufficiently close or significant to have a material bearing, in my view, on the determination of the of this scheme, then I would inevitably have to seek further information on that. But that would be a judgment should that situation arise. So it's not a case that with a guillotine date, everything stands still and nothing further can be taken into account. There would always be the opportunity for something will change down the line. Okay, so Mr. and Mrs. Many, what would your views be on what I've set out in terms of procedures, please? Do you have any comments on that?
Yeah, I think we would really like to be represented. We'd like to have the opportunity to discuss the landscape and visual effects. I feel as if we've been omitted. We've not been properly represented at all. In the, relating to the close proximity of the turbines, there's been a lack of information. There's been no face-to-face meetings. I know we've been under restricted times, but even before that, there's been a real lack of information how the turbines are going to affect us. We're not, we're just local residents, and so I think we need to understand how this is going to affect our day-to-day lives.
Okay, so
I don't know
are you?
If it's possible for someone like who's making these decisions to actually come and actually see us and see the impact that the turbines are going to have. So
in terms of site inspections, I'll explain a little bit more about that later on, but I intend to make extensive site inspections. So I'd be more than happy to visit your property, but like I say, we'll come back to that shortly. In terms of the procedure, would you, so in terms of landscape and visual sessions, you're very welcome to give evidence and participate in that. So I'll put you down on that one. Would you wish to participate in any other aspects of the inquiry or hearings?
I don't think so. I think that's the main one for us.
Yeah.
Lovely. Okay, thank you.
Thank you.
Okay, Mr. Gilmore, please. Have we got Mr. Gilmore? No. Okay, Mr. Oxley, please.
Yeah, very briefly, happy with the structure. The only part I would see myself participating in is around policy and the energy policy area.
Okay.
I'm going to add on the landscape or aviation.
Okay, thank you. And Mr. Thompson, no. Have I missed anybody? Have I covered everybody there? Mr. Thompson, have I?
No, I'm fine, sir.
Okay. Okay. Sorry, it's a bit clunky because I'm having to scroll through to be able to see everybody. So I'm just having to scan over you to see everybody's names. Okay, I think I've got everybody there. Okay. So in terms of the additional information, I didn't hear any concerns about that as we were going through. I'm content to ask for this information to be submitted under Regulation 19, and I can set this out in the notes of my meeting. What's been outlined there is relevant and potentially helpful evidence for the landscape and visual session and for assessing the effects of the proposed wind farm as fully as possible. In terms of how it's presented, that's obviously for the applicant to decide. Please could I ask you though to give careful thought to that. I'm just conscious of where we have kind of updates to updates, it can start to become difficult to follow for everybody involved. So just thinking about how it's presented to try and avoid any pitfalls would be appreciated. We can talk. I think perhaps let's talk about timescales when we come to the wider timetable for the additional information. I think that would probably be best. Any other questions or concerns or comments before I move on? No. Okay, so I'm going to move on to item 6. And now we've already touched on participation. I think I'll just go through the list again very briefly. It would be helpful to know who is likely to want to participate in each of the inquiry and hearing sessions. I can probably just check that I've recorded it correctly, having gone through that. So in terms of landscape and visual sessions, it would also be helpful to have an indication of time estimates. I know that's difficult at this stage to say how long cross-examination may take of witnesses, for example, but some rough indication now would be helpful because obviously we need to ensure we set sufficient time aside for the inquiry sessions. So if I come to Mr. Hardy first, obviously you and your team will be participating in the landscape and visual session, but what would be your best guess at maybe number of days, number of hours?
So it's going to be Mr. Denny giving evidence from Pegasus. I'd have thought in terms of supplementary questioning, maybe a couple of hours. Cross-examination, I think we need to allow 3 to 4 hours.
Okay. Thank you. And Mr. Ferguson on landscape and visual, what would be your thoughts?
Yes, well, the council will be leading an expert landscape witness, and I would agree with Mr. Hardy. It's difficult to be certain at this stage, but
yes,
particularly with virtual inquiries, my understanding is that the timescales for virtual inquiries have been slightly shorter than in-person inquiries, and perhaps a rule of thumb in the past may have been 1 full day or 1 day and a half per witness. I'm not sure if that rule of thumb would still hold in a virtual context.
It's an interesting observation. Sorry, did I interrupt? Sorry, Mr. Ferguson. Right. Yeah. So in terms of the virtual proceedings, it's I don't know. I wouldn't assume that they would be any shorter necessarily. Sometimes they can actually take longer because it is quite tiring going through a inquiry process on using virtual means, and we would probably need more, albeit fairly short breaks. We probably need more breaks than we ordinarily would have if it's an in-person inquiry. We also need to build in a bit of time should we have any technical issues that we need to resolve to be able to satisfactorily conduct the inquiry. So, but no, I think that's a helpful indication as far as we can be accurate at this stage.
Yes, I think I agree. The one experience I've had of a virtual, it was a hearing session in that case. As you said, there were more breaks and it took longer perhaps to get through the evidence. So what I was getting at was that the actual windows for giving evidence are perhaps shorter in any given day than they would be in a live inquiry. So if anything, a virtual inquiry may take longer than an in-person inquiry.
Yeah, I think that's my feeling. Okay, that's very helpful. Thank you. And okay, so in terms of landscape and visual, So I've also got Mr. Campbell first. Do you have a rough?
Yes,
feeling?
well, I have the advantage. I'm sorry. Did you ask me to speak, sir?
Yes, yes. Thank you.
I have the advantage now of having done 3 inquiries virtually and also been to court once or twice. And as long as people don't speak over each other, we can tick along quite happily as long as we have regular breaks. So I also have the advantage of knowing Mr. Denny, who is always economical with his answers. And so I wouldn't have thought that my cross-examination of him would exceed an hour to an hour and a half. My team will be fielding landscape evidence. Quite what the form of that will be yet has not been decided. But of course, I'll let you know as soon as it is.
Thank you. Sorry, I did have to mute myself then very deliberately because the bin lorry was directly outside my window. So I hope that didn't cause too much interference for anybody. Okay, Mr. Mundell, in terms of the landscape and visual session, would you wish to give evidence to that?
I would wish to give evidence, but I imagine my evidence itself will only take 10 to 15 minutes, and it would then be for others if there were questions.
Lovely. Okay, thank you. And Mrs. Many, I think. So in terms of the landscape and visual session, how long would you, I know it's very difficult, how long would you anticipate?
I think probably 10 to 15 minute talk, and would be grateful. I'd be grateful for that. Thanks. Yeah.
Thank you. Okay, that's helpful. Thank you. Does anybody else have any comments on the landscape and visual sessions? Mr. Blythe, sorry. I missed you.
Yes, thank you, sir. It just comes back to the point I made previously that we need to have sight of what the revised proposal is, and not anticipating an issue in relation to aviation lighting, but just to re-stress that caveat that depending upon what the revised proposal looks like, we need to take a view at that stage. I can't give an indication as to how long any impact might be until we know if there's going to be an issue there, but I'm pretty hopeful there's not going to be an issue. The general principle that lighting is required and that it requires to comply with the CAA requirements seems to be accepted.
Okay, right, thank you.
If I may.
Mr. Hardy.
So yes, just two points. One, yes, aviation lighting. Mr. Malcolm Spaven has created the scheme that will be dealt with. So I hear that. Second thing is really just a general point. It's about a willingness and desire to enter into statements of agreed matters where we can, if they are something that you'd find helpful, and even in relation to L&V. Going to an inquiry session, I think there's room for agreement on things which don't need to be dealt with in cross-questioning. I don't know whether the council can indicate if they've appointed a consultant, because Mr. Denny can get on with trying to agree a schedule of agreed matters with them if they have.
No, the council are still going through the appointments exercise, so the landscape architect isn't up and running as yet. But we will, of course, let you know as soon as the arrangements are finalised. And the council, as with other issues, would be very keen to explore potential agreed matters. But whether that can be accomplished within the indicative timescales as per the current timetable, where I think there's a suggestion for statements of agreed matters to be submitted by the 7th of June, that's going to be ambitious.
I hear you on that, Mr. Feggs, and I've got some comments to make about that as well, so we might be in agreement. So that's helpful. Thank you.
We shall come back to that. Okay, good. So in terms of the aviation inquiry session, again, I'll come to Mr. Hardy again, please, in terms of what you would anticipate in terms of cross-examination, please.
I think, again, supplementary evidence, if I allowed probably an hour and a half 2 hours, and cross-examination probably slightly shorter, but if I reserve 3.
Okay.
Based on previous experience.
Thank you. And I understand, so the councils aren't intending to give aviation evidence. Is that Mr. Ferguson? I'll just double check that with you.
That's correct.
And Mr. Wilson.
Yeah, that's correct, sir.
So, Mr. Blythe, what would be your best guess at this stage?
Well, I think it largely depends upon what position is being taken in relation to the aviation. If the whole question of whether any mitigation requirement is required is going to be at issue, then there's quite a lot of technical evidence to be got through to deal with that. I can, by cross-reference to another inquiry session, we have 3 days plus 2 potential overspill days assigned. So the expert evidence is pretty substantial if we have to go through all of it. So to deal with that and to deal with responses, I would have thought a period of at least 3 days is going to be required, particularly in a remote environment, probably more likely 4.
Okay, thank you. That's helpful. We shall look very closely at the timetable shortly. So if we do need, and it is a big if at this stage, it sounds perhaps less likely than I had assumed, but if we do need a session on ornithology, Mr. Hardy, have you got any views on that? I appreciate currently we don't really know the scope of that, so it's going to be very difficult. My gut feeling would be a day would be ample, but what are your views?
I mean, very difficult given that we don't think you need one at all. So I'm not going to change from that position. Yes, I mean, a day would seem ample.
Yeah, my sense is that we probably won't need that from what I've heard this morning, but it's helpful, I think, just to keep it in mind. And Mr. Tooth, do you have any views?
No, we're in agreement with that. A day would be more than ample, but yeah, hopefully it comes out.
Lovely, right, okay, thank you. And does anybody else have any comments on the inquiry sessions, timescales and so on? Have I missed anybody? No. Okay, so for the policy hearing and the conditions and legal agreement hearing, I'd anticipate that these sessions could potentially be held back to back, possibly in the same day, but it may be safer to allow 2 days for those sessions just in case they become more protracted. I don't need to know who wishes to participate in that session now, but you'll have an opportunity after I issue my note of the meeting to confirm whether or not you intend to participate. So for the conditions hearing, I've already indicated I'd like a schedule of conditions to be prepared with confirmation of whether the conditions are agreed or disputed between, in particular, the applicant and both councils. But also, I appreciate, Mr. Campbell, you said you would wish to have sight on that and have the opportunity to comment also. And if they're disputed, it would be helpful to understand the nature of the dispute and any alternative wording or additional conditions that would be suggested. And then that obviously would then be the focus of our discussion in the hearing, because the hearing will largely focus on matters of dispute. Can I ask the applicants, Mr. Hardy, can I ask you to take the lead on compiling this schedule, please, noting the need for both Section 36 conditions and conditions for deemed planning permission as well?
Yes, that's fine.
Thank you. And in regard to any legal agreements, again, it's helpful to set out the matters it would cover, and again, any areas of dispute. So, statements of agreed matters. You've given me forewarning there that you have some comments. A number of people have comments on this. So, my thinking around this is that the focus of all inquiry and hearing sessions will be on matters where parties do not agree. So statements of agreed matters on the topics to be addressed at the inquiry and hearing sessions can be very helpful in focusing evidence and discussion. So for this reason, I think it's preferable to have them submitted relatively early, so that subsequent submissions can focus on those matters of dispute. I appreciate. Well, I'm not wedded to the timetable. Mr. Hardy, you said you had some comments on that. So could you share those, please?
Yes. So I'm going to suggest the guillotine date for cumulative consideration purposes is the end of May. That the additional information comes in by the 18th of June. And then the end of the first week in August, that's the 6th of August, everything else, so that's core documents, statements of agreed matters, the draft condition, and then any ecology statement on aviation lighting. And that's with an eye to the inquiry session starting in the last week in September, first week October. So just to try and space it out, we'll obviously come on to the dates of the inquiry, but it's worked out on that sort of assumption. So end of May, 18th of June for additional information, end of the first week in August for the other matters. And if we were going to have a second PEM, then my suggestion would be that that's sometime in the middle of August, because by that stage, hopefully there'll be greater visibility on whether or not a physical inquiry is going to be possible. But also, there does need to be a line drawn under that discussion as well. Everybody needs to know where they are. So trying to strike a balance between sort of hope and certainty.
Thank you. Mr. Ferguson, please.
Thanks, sir. Yes, there are a number of points here. Firstly, in relation to conditions, the timetable, as is it seems to anticipate the relevant parties submitting their own proposals on the same date. Whereas I understood your suggestion would be that the applicants would produce a first draft of both the Section 36 and planning conditions, with the other parties then feeding into that process. Is that correct?
Yeah, so I'd like the applicant to take a lead on pulling that first draft together. I mean, there's always an element of you're working together to make that happen, I'm sure. But I think having a first draft to work to, we can then have further iterations of that further down the line, if that's possible, to actually reach further agreement.
Yes, that sounds a sensible approach. And what was Mr. Hardy's suggestion of the 1st of August, I think it was, for conditions, was that intended to relate to the applicant's first proposals, or for the consolidated version with comments from the council and other parties?
If I can jump in, certainly the idea was to try and get to a position of agreement by then, Mr. Ferguson. So that was that's where we get to as of 6th of August. And if necessary, it can be a parallel schedule of this is what we're suggesting, and this is what the council is suggesting.
Thanks. That's helpful. It would be helpful to have the parallel schedule, both in relation to the conditions, and also it tends to be conventional for the applicants to lead on matters of proposed agreement.
Yes, that's right. I mean, the scope of statements of agreed matters is obviously down to parties to set out, and that will have to be formulated through discussion. I'm quite content with having a later date for the statements of agreed matters, as long as parties are also content that then reduces the window for that to shape the inquiry statements and subsequent submissions. Obviously, my hope would be that the early statements of matters are available and they're of some substantive use, then they can help to focus the evidence that you then subsequently produce, and you aren't producing abortive work either. So that would be my hope, but obviously it's down to parties. There may not be agreement, or it may not be worth setting it out because the differences are too great. So there's no obligation. It's just it's exploring how much can be achieved.
Thanks. That sounds a helpful approach. I should flag at this stage that the council is currently considering how the council will proceed in light of the additional information which has been discussed. In terms of the council's scheme of delegation, the consideration of the application for the consultation was dealt with by the Planning Applications Committee. Now, clearly there will be further consultation in terms of the EIA regulations. I'm not clear at the moment whether there will be a further consultation under the Electricity Act itself. That the application seems to be changing by virtue of the aviation lighting reduction. So the Planning Application Committee deals with consultation under the Electricity Act, which is a separate process, albeit it tends to be dealt with in parallel to consultation under the environmental impact regulations. So I just need to get to the bottom of what involvement, if any, it will be necessary for the Council's Planning Applications Committee to have. And the timing is slightly unfortunate in that there is a Planning Applications Committee on the 23rd of June, which is only 5 days after the proposed submission of the additional information, with the next scheduled committee being on the 25th of August due to the conventional recess in July.
And presumably there are some associated lead-in times. I don't know what Dumfries and Galloway Council's lead-ins are like for committees. I know some can be quite protracted and others are relatively quick. Do you know?
I am aware of the lead-in times where it's a planning application. Of course, the Planning Application Committee tends to deal mainly with planning applications. One of the issues we're investigating at the moment is lead-in times for an ad hoc consultation such as this.
Okay. Mr. Hardy, do you have any thoughts about if the council is obliged to take something to committee to finalise its view, that obviously has an implication potentially in terms of deadlines that we may set for additional information and so on.
Yeah, I think the view is that certainly aviation lighting, the change, that would be the subject of a condition. That isn't a change to the scheme. So I mean, it's the first obviously I've heard that the council is has a sort of governance issue. So I was just listening carefully, but my view, there isn't any requirement to take it back. So I propose the timing that I have done. I'm not sure I've heard anything which causes me to change my view on that.
I mean, to some extent, it is a matter for the council to ensure it can report in a timely manner. I appreciate it does fall awkwardly. I don't know whether there's scope for extraordinary meetings should it find itself in a position where it needs to take it to committee and form a view. Could I leave that with you, Mr. Ferguson, and perhaps you could flag up? I think it probably needs a little more sort of careful consideration around whether or not it needs to go to that committee.
Yes, sir. We have already started those discussions, and I would hope to have a definitive answer by perhaps the end of this week, and I will update you at that stage. At the moment, I don't intend to suggest changes to the timetable to accommodate any such requirement, but I just wanted to flag up the possibility at this stage. It's no more than that.
Thank you. No, that's helpful. Does anybody else have any questions or comments about statements of agreed matters?
Can I just make clear too, in terms of the suggested date of the 6th of August, that again, like the conditions, is a date for submission of the completed document. The intention, certainly from the applicant's side, is to get on with those straight away. So as soon as, I mean, in the case of the L&V consultant, obviously the council needs to appoint one, but as soon as that appointment is made, then we want to get on and agree with all parties what we can. So I just wanted to be clear, 6th of August is not the start of that process, it's the end of that process for submission to yourself.
Absolutely. Yeah, no, I'm very much focused on deadlines. Mr. Blythe.
Sorry, I think it's me, but can I just check when it's suggested that the draft conditions are going to be circulated? I think we're talking about 6 August for finalisation of the position, which
as far as possible.
fine,
Yeah.
But is it still envisaged the draft conditions will be circulated on 18 June? And I should also flag that I think GPA would want to be involved in the conditions to the extent that they impact upon aviation radar and by extension the conditions hearing.
Yeah, I mean, I don't necessarily need to set out the start date essentially, or for different iterations of it. I'll be focused on whether they're available publicly and to me. But Mr. Hardy, I don't know if you'd have any comments on what Mr. Blythe has just asked.
Well, I'm really taking your point, and the one I hope the message that I'm putting across is we want to get on with things early, and everything that can be done at an early stage will be done, and those are the drop dead dates for delivery to yourself.
Okay, thank you. Is that okay, Mr. Blythe?
Yeah, that's fine. That's just I saw on the draft timetable it was suggested draft conditions circulated by 18 June, but I think Mr. Hardy suggested.
Well, I'd certainly give comfort. I mean, yes, and if it can be early, would be. But we're very keen to get on.
Yeah, fine. That's helpful.
Good. So unless there's anything else on statements of agreed matters, we shall move on to item 7, which is looking at dates for the inquiry and hearings themselves. So there have been some exchanges over possible inquiry dates between some parties. I'd initially hoped, perhaps optimistically, that a July date would be possible. Clearly, that's not an option and wouldn't work in anybody's interests, given what we've discussed this morning. And also, obviously, that would fall within the school holidays as well. So October is looking like the soonest suitable option. Now, Dumfries and Galloway Council and Glasgow Prestwick Airport have both indicated previously that they had a preference for the inquiry to be held next January. Scottish ministers expect inquiry processes to be held promptly, and I should make clear now that postponing the inquiry for such a long period would be a last course of action if there were no other available earlier dates that we could settle upon. So, working on the assumption of an October inquiry, I've set out in Appendix B, but then I issued Appendix C, which last week, which I'd like to make reference to specifically. Set out the associated deadlines. We've already talked about some of those for various submissions on the lead-in. You'll see that I'm suggesting we hold all sessions over a 2-week period, and might need to look to 3 weeks if we need an aviation session in the weeks beginning the 11th and 18th of October at this stage. So I'd like to hear from everybody in terms of the views on those dates, and also the order of sessions as well. So Mr. Hardy, could ask for your views, please.
Yes, thank you. I mean, the obviously there is a keenness to get on, and a delay through to early part of 2022 wouldn't be acceptable to the applicant, but I don't hear that really being on the table. Second point then, in terms of dates, there's a preference for September. I hear what's been said by the other parties in relation to that, but I wonder whether or not the last week in September, which straddles into October, so that's the week commencing the 27th, the 28th, and the 29th for LVIA and Visual Matters, and then the following week, the 4th, 5th, 6th, 7th, and 8th of October for the other sessions. That would be our preference. As I've indicated, there are hotels available for that period. If that wasn't possible and the dates were put back into October proper, then there's a constraint from Mr. Denny in relation to the first couple of weeks where he can't be there. And I think the final point is in terms of order, there is a clear preference that the planning matters are dealt with after the L&V matters and hopefully the aviation matters too, because very often in the course of these things, the planner needs to sweep up. So I'm not going to die in a ditch over it, but there's a very clear preference stated for the I don't mind whether it's L&V or aviation that comes first, but that planning should come last in order. So those are the points I would make. And if we then need to come back and shuffle dates in October, I can come back to you. But the first couple of weeks are when Mr. Denny is not available.
Okay, thank you. Mr. Ferguson, do you have dates in front of you? What does that sound like in terms of Mr. Hardy's proposition that the 27th of September would be the start date?
Well, sir, we prepared on the basis of the revised Appendix C timetable and the availability of the, if I can explain, two landscape witnesses have been shortlisted at the moment, and I canvassed their availability for the timetable as per Appendix C, and both potential candidates are available for that timetable. I know that one of the candidates wouldn't be available during the first week in October, but I'm afraid that I don't have his availability before that into September. Mr. Duncan may have, I'm not sure. I know that Mr. Duncan has been in touch with the potential candidates. But if he doesn't have that information, it's something that we would need to double check before committing to a particular timetable.
Mr. Duncan, thank you.
If I can just clarify the point of the two landscape witnesses, they are both available during the entirety of October, apart from with one of them week commencing the 9th of October. So we've got a degree of confidence we can provide a landscape witness if the inquiry sessions take place during October.
Have either witnesses given an indication about availability in September?
No, sir, that question hasn't been asked of them.
Okay.
If it may, it's only a couple of days. It's that week straddling September, October, and it sounds as if the council haven't appointed. That isn't a no, and it may well be. I don't know whether you can make even a quick call now, but it's not a stretch. We're not saying early September. We're saying that last week anyway.
Mr. Campbell, please.
Thank you, sir. I'm afraid I'm not available in that week of September the 27th, okay. Except on the Friday, the 1st of October. I could not be available for the first 4 days of that week. I'm sorry to be an impediment to progress, but I am available for the remainder of October.
No problem. Dates are usually the most challenging part of an inquiry, so no need to apologise. Do any other parties have any comments on the possible dates, either as I've outlined in Appendix 6 and as Mr. Hardy has proposed? Mr. Blythe.
Yes, thank you, sir. So far as that week commencing the 27th of October is concerned, that, for the reasons which have already been discussed, hasn't been checked with GPA's experts or indeed their team. I'd actually understood from the applicant's solicitors that they were not available on the 30th and 1st of October of that week, but it sounds like that's perhaps now changed with the result that they are available that whole week. So we can go back and check that week, but I think the suggestion was that it would be week commencing 27th September for the landscape and visual, and then we would be into week commencing 4 October for the other matters to include aviation. That week commencing 4 October looks to be okay for GPA, both in terms of factual witnesses, experts, and also representatives. Once we go past that week, we get into bigger problems, largely brought about as a result of holiday commitments. But that week commencing for October would be okay for an inquiry session in relation to aviation.
Okay, thank you, Mr. Blythe. Mr. Hardy, would that? My understanding is your team aren't available in that week. Is that correct?
So,
on the 4th of October.
So Mr. Denny is not available in relation to L&V matters, and I mean the other possibility is the week before. I don't know whether consideration is being given to the week of the 20th of September. Mr. Campbell, I hear, said he's not available that week of the 27th. I don't know whether he's available on the week of the 20th or whether others are.
Mr. Campbell, I think you're speaking, but you're muted.
I'm sorry.
No, you're fine.
I'm sorry to be boring, but I'm not available that week either. It's a matter of self-interest, but I'm on holiday that week and working the week after, the 27th.
The week commencing the 20th of September is potentially problematic for me as well. So I think let's still stay away from that one. Mr. Mundell, I saw your hand up.
Sorry, I was just going to say, the precognitions are only due on the 20th of September, according to, I think, the sort of deadlines as well. So it's just then whether that's realistic to go with that week.
Yeah, I mean,
if it's not available anyway, then that point's irrelevant.
In terms of, yes, it's a good point though, and in terms of the sort of leading deadlines, they may be adjusted depending on which dates we ultimately settle on. So there has to be sufficient time between each stage to enable that. Okay, so in terms of what may work, then I think so. Sorry, Mr. Blythe, I'll just double check with you. Did you say so the 4th of October was a preference for, or a possibility anyway, for aviation matters in that week?
Yeah, if we're having an inquiry session on the aviation safety issue, although for the reasons I said before, I would anticipate it taking most of that week. So I think it had been suggested week beginning 4 October for other issues other than landscape and visual. I think I would be anticipating week commencing 4 October for aviation radar issues only.
Yes, subject to the point that I raised about order and about planners coming last in time. I think that's where that difficulty comes in, because Mr. Denny isn't available until the 15th. I think we've indicated that to the unit. So the pressure then might be to put in, well, planning, policy, the conditions, and aviation. So that runs. I'm happy with aviation, but you run straight into the problem of the planner coming before the other substantive topics if you put it all in that week.
I think I understand your point about the preference. I don't feel quite as strongly as you, Mr. Hardy, in terms of the order of events. In an ideal world, my preference would be to have the planning hearing session after the other sessions, but from experience, it can work the other way around as well, perfectly satisfactorily. And then we do have the opportunity for closing submissions to pull everything together as well. So I don't think that's a fatal issue. However, I think perhaps we might be able to order things so those hearing sessions, or certainly the planning and the planning policy session, could come last. Now, my thinking, unless I've missed something blindingly obvious, and please do tell me if I am, if I've just completely ignored what you've all told me, but if we had the 4th of October and we set that week aside for aviation matters, and time will tell as to whether or not we need that session, we could then look to there would be a break, so we wouldn't have anything in the week commencing the 11th of October. Then we would have the landscape and visual inquiry sessions in the week commencing the 18th of October. Now, from what I've heard, 3 days should be more than ample for that. So I think if we assume it would be 3 days for the landscape and visual session in that week, that then, assuming we're all willing and able to do a full 5-day week of sessions, we then have 2 further days that week to be able to have a policy session and a conditions session. Does that sound workable and reasonable to everybody, or please tell me if it doesn't?
Yes, that sounds workable to us.
And yeah, Mr. Campbell, sorry, hand.
Yes, it does sound workable. Thank you.
And Mr. Ferguson, I understand from the council's availability that's been indicated that should work from a landscape and visual perspective.
It should, yes.
And for other parties, does that all look to be workable for you? Please just tell me if it doesn't. Okay. Okay, well, that sounds promising then. I think we'll proceed on that basis then. So just to confirm, I'll set all this out in the note of the meeting. We would have the 4th of October for aviation, and we'll put that whole week aside. We'll have a break, so there's nothing in the 11th of in the week commencing the 11th of October, and then the remaining sessions will be held in the week commencing the 18th of October, and with the landscape and visual session first, followed by the hearings. Okay. So in terms of process leading into the inquiry, essentially the idea is that all participants in a session have given prior notice of their arguments and of any documents to which they intend to make reference to. So this ensures fairness for all parties and allows for counter arguments to be prepared. So all parties taking part in the inquiry and hearing sessions must submit an inquiry or hearing statement. They'd be copied to each other, and the deadline appears in Appendix C, as I've suggested. And there's no word limit for those documents. Now, these statements should outline your case. They should list any documents to be relied on and identify the witnesses who will speak at the session and the topics each will cover. So any documents which you intend to refer to at the inquiry or hearing sessions should be lodged by the date, which again will be specified in the note, and you'll see in Appendix C. So a number of documents are likely to be commonly referred to by a number of parties. Please could I ask, Mr. Hardy, could I ask the applicant to take the lead on preparing a list of core documents, please?
Yes. And I was, I think, suggesting that date at the end of the first week in August.
Yes, you were, and I'm satisfied with that. I think that fits with what we've discussed. So the core document list should help to minimise any unnecessary paperwork or duplication of documents on the DPA website. So we already have a number of submissions. So if a document's already been lodged, then the core document list that you produce can simply give the document a reference number and then include a hyperlink to the document on the DPA website rather than resubmit it. So all core and other documents should be lodged electronically, and they need to either be in Word or PDF format, except illustrative material, for which paper copies should also be provided. So I'd also ask all parties, please only submit documents to which you actually make reference to in your evidence or intend to make reference to, rather than a more extensive reading list. It just keeps everything more accessible for everybody. Any questions about documents? No.
Is that
witness giving? Sorry, sorry, I didn't see who spoke. Mr. Hardy, sorry.
Is that just one hard copy? So in terms of the illustrative material, I think you said that you want a paper copy. Is that just one version to yourself?
I suspect at the very least, actually, the Dumfries and Galloway Council would be requesting a copy for their witnesses. So do you have a view on that?
Yeah, it would be very helpful to have at least 2 hard copies, one for the witness and one for either myself or counsel who will be conducting the inquiry.
I think that can get a little bit out of hand. If I might suggest that one hard copy, and then obviously other copies could be made by the various parties. Could I try and limit that to I don't mind. I quite agree that all parties should can expect to have one copy of those illustrative material, but can I suggest it's limited to one per copy, sir? One per party.
I don't think that's unreasonable. I think, Mr. Ferguson, would that cause you great difficulty if you had one copy?
Well, we would typically have at least 2 hard copies available, and if I would have anticipated that it would be relatively straightforward, given the scale of the task for the applicants to hit print twice. I know it's more involved than that, but relatively speaking, I think it would be more straightforward for the applicants to produce 2 copies than it would be for the council to take a copy and then have to manually prepare a further copy on the back of that.
There's something to bear in mind there in terms of if things are being reproduced because they need to be reproduced, then there's always a fear, certainly with me, that has any accuracy been lost or quality. So I think Mr. Hardy's heard your request. I shall leave it with the applicant to consider. Obviously, currently there's not a requirement for a deposit copy to be provided, so that's one less copy that would actually, or a number of copies potentially that don't need to be produced. Mr. Campbell, please.
I'm going to indent for a hard copy, sir, for the multiplicity of third parties who I will end up representing. Really, it's conventional that these are supplied to the public in a public forum. That doesn't seem to be happening at the present time. I can manage perfectly well with an electronic copy, but the public generally find that quite difficult in my experience. So, understanding as I do that Mr. Hardy's clients may see a serious cost difficulty with producing additional copies, nevertheless, I would request one if it can be made available.
I think in terms of the parties who are participating in the landscape and visual session, I think that's a reasonable request. Mr. Hardy, can I leave that with you, please?
Yes, I mean, I was agreeing, so absolutely, that those parties engaged one hard copy per party. I think that's absolutely right. My concern was multiple copies. So I said what I've got to say. I'll leave that with you. Okay.
Right, I understand the situation. I think I'll set out in the note what my requirements are, and then any discretionary additional copies would be for parties to discuss. So in terms of so we've covered documents. So in terms of other submissions that would need to be made, so each witness giving evidence to the inquiry sessions, so not the hearing session, must submit a precognition. So the deadline for this would be no later than 14 days before the start of the inquiry, that's the first inquiry session. So each precognition must be no more than 2,000 words. I'll not accept appendices or links which extend the length beyond the word limit, or introduce documents which other parties have not previously seen, as these should be submitted by the early document deadline. Regarding further written submissions, I'll confirm details of the information I'm seeking and from whom in my meeting note, together with the deadlines for this. I'll also set out, as I said, the request for the additional information which the applicant intends to submit. Are there any questions under item 7 before we move on? No. Okay. So moving on to item 8 on the agenda. So this is in relation to site inspections. So the timing of my site inspections will be dependent to a large extent on COVID-19 restrictions, inevitably. All being well, I intend to make extensive site inspections unaccompanied prior to the inquiry, and I may also make follow-up inspections once I've heard the inquiry evidence. So as I say, I expect to be able to carry out most, if not all, of these myself. I don't need to be accompanied. The exception to this may be where I need to visit certain residential properties. That said, I don't envisage needing to enter any houses, but I may wish to enter the garden ground. So my suggestion is that via the office, we'll be in touch with relevant parties when I intend to make such site inspections, and if necessary, we can discuss this again at the start of the inquiry. Does that sound like a reasonable approach? Is anybody concerned by the fact that there may not be accompanied inspections? No. Happy for me to do that. Good. Okay.
The only point I would make is that past experience, it's helpful to draw up an itinerary or a group of those, or a map showing those locations that the parties would like you to visit, even if that's on an unaccompanied basis. So we're very happy to put that in train and to try and get that agreed, both the council and Mr. Campbell and his clients, if you would find that helpful. The idea being to try to sweep up all those points and viewpoints that we think you ought to have a look at.
That would be very helpful. Thank you. I probably won't confine myself to that list.
No, of course not. Yeah, but just so that
certainly,
you've at least covered those points that we want you to see, and then obviously you can go and see whatever else you choose to do.
Yeah, I would agree with that, sir.
Okay, thank you, Mr. Undell.
I was just going to ask if that list could be circulated to all participants, if that's possible, just in case.
Yes.
Just so as not to duplicate. Just so as not to duplicate with a further list.
Yep, I think it can be a compendium. All parties putting all parts that I mean within reason, but sensibly all places that we would like you to go and have a look at.
Lovely. No, that sounds very helpful. So on that note, actually, one matter which I've noticed is that I may be missing something, so please just point me in the right direction if I am. But I've not been able to find, for all of the representative viewpoints, a very clear location plan. So it's not to pinpoint the exact location from where a visualisation or wireframe has been produced. Obviously, that's not a problem for a hill summit where it's obvious where I need to be standing, but it appears that others might be more challenging. I've seen in some of the cumulative wireframes there are some thumbnail location maps which are ideal. So if I could have either point me in the right direction if I am missing them, or otherwise if I could have a set of thumbnail location plans for each viewpoint,
we'll
that would
do
be really helpful. Thank you. Okay, so there are a few miscellaneous bits just to cover before we conclude this section. And I'm now under item 9. So the most effective way of keeping abreast of this case and the proceedings will be the DPA website, where all the relevant details and documents can be accessed. And I'll include a link to this specific case in the meeting notes. So the use of the website is of even greater importance currently, as obviously the disposal restrictions mean there won't be a public copy of documents on deposit locally. So the website is the key resource. In terms of contacting the DPA, if you wish to contact us about the case officer is Jane Anderson. And again, I'll put her contact details in the notes of the meeting. Now, because the case officer is currently working from home, she doesn't have a direct phone number which can be used currently, but she can be contacted very easily on email. The main office also is still taking calls. So in terms of when we get into the inquiry and hearing sessions themselves, the normal kind of daily programme would look like, so the first day would start at 10 AM and subsequent days I'd look to start at about 9:30 and conclude by no later than 4:30 or 5 PM. There'll be short breaks in the morning and afternoon, a break for lunch of about an hour, which we'd look to take between 12:30 and 1 o'clock. If it is a virtual inquiry, we're likely to need extra breaks, as I've said, and we can play that by ear. But it's important that we're not too ambitious with how much we expect to get through and with how much progress can be made in a day. I think we, in terms of the time that we have available and from your best guesses in terms of time estimates, I think we're on fairly safe ground in terms of having adequate time to complete the sessions in the 2 weeks that we've identified. So whether or not we have an in-person or virtual inquiry, it's intended that all sessions will be live streamed. I recognise this was intended to be live streamed and we haven't been able to because of some technical issues today, but the intention will certainly be that it is live streamed. At the very least, it will be recorded and so it can be viewed back again. So should the inquiry have to take place by virtual or restricted kind of socially distanced means, this still ensures the public can follow the sessions. So I'll now produce a note of the meeting, which I'll aim to issue within the next 7 days. So this will confirm the dates and all the other matters which we've discussed this morning. So parties must notify the DPA within 14 days of receiving the note of the meeting as to whether or not they intend to participate in any hearing or inquiry sessions, and if so, in which they intend to participate. Mr. Ferguson, I saw your hand up.
Yes, sir. I should have raised this at an earlier stage. It's to do with the final step in the timetable for the closing submissions. Okay. The indicative timetable suggested a period of 2 weeks, I think it was, between the last day of the inquiry session and the council and other parties other than the applicant submitting their closing submissions. 2 weeks, I have found, is very tight. It's very difficult at this stage to know availability of the key individuals to work towards that. So I would request that particular step be extended to 4 weeks from the last day of the inquiry session, or indeed the hearing session if the hearing is taking place at the end of that week.
I have no problem with that. I will not be short of work at that point, so I'll be able to make good progress writing up the report in the absence of closing submissions over that 4-week period. Mr. Hardy, would you want additional time for the applicant to submit closing submissions? Currently, you've got 2 weeks from obviously the date of other parties submitting closing submissions.
Well, first of all, I don't think 2 weeks is too short a period. It seems to me that given the small number of issues that will be live, even on a worst case basis, that 2 weeks would be enough. So I've heard what's been said, but my position would be that 2 weeks was enough. I will need some time, obviously, but 2 weeks will be plenty. So my position would be that it ought to be just 2 weeks plus the 2 weeks, but you'll have to form a view on the application that's been made by the council. Just while I'm on, can I raise one other point? And it's this: in the timetable, just want to make sure that it hasn't got lost, that you're going to allow Mr. Campbell some time just to come to a view on whether or not there's anything at all to deal with on private water supplies, peat and ornithology, and what needs to be built in there is time for the applicant to respond.
Absolutely. Yeah.
So we need to see, hopefully there'll be nothing at all. That's what we're expecting. But if there was, then we need to be able to be given time, not just to see what the position is, but also time to react to that. So I just ask for that suitable provision to be built into the timetable when you write it up.
Yeah, absolutely. Yes. Yeah. No, I've got a note of what I've said to Mr. Campbell, and completely understand you will need the opportunity to respond. Yeah, don't worry.
Very grateful. Thank you.
Lovely. Okay, so going back to the closing submissions point, I hear your view, Mr. Hardy. I'm content to allow parties 4 weeks from the end of the inquiry to submit closing submissions. As I say, that won't cause any delay to the ultimate issuing of the report, as I'll have heard all the evidence, except obviously seeing the closing submissions, and I'll have more than I need to be making progress during that time without closing submissions having been finalised. So I'm content on that point. Mr. Campbell.
It's generous to give parties 2 weeks, sir. It's very generous to give them 4. You might be amused to know that at a recent inquiry in England, when I asked the inspector for a week, she said 2 days, Mr. Campbell.
So certainly what I'm used to, Mr. Campbell. In fact, actually on the normally if you finish the Thursday, it's the Friday morning at 9 o'clock. So I think 4 weeks is generous. But anyway, I made my point. So
no, that's noted. Yeah, no, and as I say, I'm satisfied it won't compromise any progress on the case, and on that basis, I'm satisfied with allowing 4 weeks and getting the quality of response that I'd expect in closing submissions from the council. Okay, so has anybody got any other questions or matters which they'd like to raise before I conclude the session? No. Okay, so thank you very much for your input this morning. It's been really helpful. I shall, as I say, issue my note within the next 7 days. If you've got any queries about that, please come back to us. So thanks again, and take care, and I'll see you later in the year. If we need a further PEM, then I shall set that, but obviously at this stage we shall keep that open, and I'll keep it, I'll monitor the situation and see whether that's going to be necessary. But otherwise, we'll see you on the 4th of October. Okay, thank you.
Thank you very much, sir.
Thank you, sir.
Thank you.
Thank you.
Thank you. Bye-bye.